There are ideological decisions that he has taken, but fundamentally at a level of activism. The decision to definitely now tell the United States that in his opinion there are two genders in the whole world, of course, is a sharp diversion from the Democrats. So clearly, however criminal you are, the kind of crime you commit cannot be a procedure for recruitment into the UPDF. Accordingly, you cannot be disciplined as a member. That the M23 have even the capacity of taking over the government of Congo. They have all become the catechists. The president is just the high priest celebrating the mass, but he doesn't even administer the Holy Communion himself. So now that is the problem in Congo.
Hello my viewer, and welcome to this special edition of The Perspective, broadcasting from Kampala. On this show we discuss different issues, and today we are going to discuss geopolitical issues, regional and global, things that shape the world in which we live today. From the impact of the US policies after Trump's inauguration, closer to home, East Africa faces its own challenges, including the tensions that escalated due to the controversial military trial of Dr. Kizza Besigye, which began with an alleged kidnap from Kenya. To break down these pressing issues, we are joined by a man of very many titles, Dr. Hon Mukasa Mbidde, a distinguished lawyer, a former legislator at the East African Legislative Assembly, EYALA, and he's the legal representative of Umubano, an association of Banyarwanda living in Uganda. He is also the deputy president of the Democratic Party. Honorable Dr. Mukasa Mbidde, thanks for making time to speak to us.
Thank you, my brother. It is definitely an honor for me to be featured on The Perspective. Definitely, I can guarantee that we shall give it all and sundry. What obtain is at the subconscious level of my brain at the time. It usually determines the kind of diction I can use in the circumstances. So I can either be eloquent, I can decide to be grandiloquent, or sometimes I can decide to be magniloquent, depending on obviously the environment I am in and the intent and purposes of the message. Yes.
So, Honorable, let's begin with global and regional geopolitical shifts.
Yes.
With Trump's return to office, how do you see his administrative, domestic and foreign policies affecting Africa, particularly East Africa?
First of all, we are beginning to look at the effect. It is fundamental. Trump comes off as a business-oriented leader. He cannot be listed among us to those that are politically correct in all decisions that he takes. But he actually comes off as a substantive nationalist, somebody who looks at the interests of the United States people. In terms of foreign policy, Trump looks at it using lenses of profit and loss. The amount of money that America spends on a substantive country, Trump looks at it in terms of how much benefit, again economically, the United States of America can definitely recoup from such expenses. So in so doing, he has taken decisions a bit differently. The decisions he takes have the effect of returning the United States from a substantively imperialist United States to a kind of a country that now looks inwardly to its own people and its development. A country that actually is business-oriented, profit-oriented, more than the philanthropic country that it has always been. So that has determined and informed the kind of policy decisions that Trump espouses. Of course, at some stage he has contradicted himself. When you look at the Trump of 7 years ago, the decision is to definitely, of course, increase even their input in terms of World Health Organization, is now ultimately the opposite of what he has taken as a decision in terms of trying to skedaddle from the laid out path of their involvement with the World Health Organization, for example. However, they are ideological decisions that he has taken, but fundamentally at a level of activism. The decision to definitely now tell the United States that, in his opinion, there are two genders in the whole world, of course, is a sharp diversion from the Democrats and what they have been espousing. There are countries like Uganda that had begun suffering cartels against their own market access to the United States, given the enactment of the Anti-Gay Act here in Uganda. When now Trump comes in and determines that actually it is supposed to be two genders, and that homosexuality, in his opinion, is not actually a straight path of sexual orientation, I am looking at Uganda as having the ability to regain its own quotas that we had lost under the African growth. But now, what should the African countries look at? What has Trump decided? Because when foreign aid that definitely has been geared towards alleviating the health inconsistencies of African countries, eradicating diseases, and ameliorating the effect and impact of such infectious diseases in African countries. For example, like HIV, when you find that Trump has retrieved their contribution, of which was between 18% to 25% contribution, if they have established a stoppage thereof, what is the likelihood of impact in terms of escalation of such diseases to the African countries? Already South Africa had reached the stage of 95% achievement in terms of the fight against HIV. 95% meaning that 95% of the HIV positive persons, first of all, are aware that they are. Number two, that they have been placed on capacities that can elongate their own lifespans. Number three, that 95% of South Africans should be in a position to know their status. They call it serostatus. There is something they call it that is actually medical. So that kind of achievement obviously is now going to be reversed, given the stoppage. And in fact, the stealthiness with which such stoppages have actually been adopted, that immediately stop and the experiment of a 90-day, the 90-day experiment established by Trump, you find that African countries need now to do a lot. Number one, prioritizing health. So the areas that have been funded by the United States were not being funded simply because the United States has a duty, is not duty bound definitely to fund African states in terms of their own health environments. Number two, what has been the basis of such? Has it been based on agreements? Number three, there are legal issues that actually arise within the United States itself domestically, that pursuant to such diversions from what otherwise had been a life subsistence to the African economies in terms of health. President Trump definitely has trampled upon certain legislations and laws in the United States. And by executive order, it is very unlikely that it can take effect, while the same is contrary to legal provisions within the land. So what African countries need to do is to begin locating the possibility of lawyers now within the United States, reaching out to the courts within the United States, having the effect of a possibility of rescinding some of the orders taken by Trump. Now that is one of the urgencies.
Because they can only be done in court.
That can be done in court. Number two, African countries now need to prioritize. They have actually not been unanimous on non-alignment when it comes to issues where the United States has got substantive interest. foreign interest. Some have been unaligned, others have been aligned. African states should now start thinking of being either all non-aligned or uni-aligned. They must take, now decision is by African countries. First of all, have to be based on sovereignty. Now they must begin to think sovereign. Because United States has been also operating in such a way that once they have got interventions that are done by way of philanthropy, by way of funding certain activities, there has been some indirect procedure that actually also gives the United States a fulfillment of its own foreign interests. For example, the fight against Al-Shabaab and the fight against substantial terrorists really did not commence as if it is an African problem. Bin Laden did not hit Africa until Africa started becoming, of course, establishing stages of attack against the Al-Qaeda. So we have been partners in fights against insecurity to the United States, but at the same time also establishing that cohesion and camaraderie between us and the United States. That has accounted, in such a way, it was then fair and fitting for the United States to also do its part by ameliorating the kind of health problems that we have in Africa and of course development issues that we would have in Africa. Number two, the African countries need now to begin talking of partnership programs in terms of business. The imperialist nature that we have actually been, it had established an umbilical code of conviction to all African states that actually our mother is the United States. Now, this has got to be supplanted and replaced with a robust design by African countries to insist on trade partnership that actually benefits African states.
Wow.
Now, that is something that we must do. I expect now leaders of the African Union to convene as quickly as possible as an answer to the style of leadership by President Trump that seeks to establish now robustness of unity as African states. Now, the time to begin thinking of African statism is now, so that the United States needs to know that what they have been doing, they have actually been benefiting in a different way.
I hope our African leaders take your advice. Whether they do it or not, we shall still see, we shall be there to see how it unfolds as time goes by. So, Honorable, I want us to come briefly back to the region. What does this mean for the political, the geopolitical stand in the region? And what is maybe Uganda's role, if you can speak to this as well? What is Uganda's role in such a scenario?
In a scenario of this nature, there is no singular East African country that has a bigger role to play. But the East African Community bloc has got a substantive role to play. I am saying no singular country should have a role to play because the politics of DRC is such that once any country is identified as capable of having a role to play, then they quickly run against that country, create scapegoatism against that country to the extent that their own robust public relations machinery is unleashed to that country, against that country with the international world, to the extent then that it is beginning to be viewed using the lenses of a likelihood and a possibility that that country is actually helping M23. Why am I saying so? Because at a question of right and wrong, there is no middle line. Something is either right or wrong. What the M23 are fighting for is right. So anybody wanting to involve themselves in terms of what to do definitely must come using the right lenses of correctness. These are Congolese. The Congolese that have always faced upheavals in their own country simply because they speak a different language. Now, if you need to look at the history of the involvement of Kinyarwanda speakers in Eastern Congo, you can call it the former Masisi territory that substantially again got divided into North, South, and Central Kivu. When you begin to look at the period of 1918, for example, between 1918 to 1931. Their relationship between the Bahunde and the Nyangas, the relationship between, and what caused the 1931 decision between the then white leaders and the Banyarwanda, thereby being appointed chiefs of their own areas in those areas. Then what ultimately metamorphosed into a problem after the 1960 constitution of DRC that ultimately culminated into substantive elections that followed between 1962 and 65. Now, we would say that there were society disagreements during that time. They were social. But the political disagreements ensued when now the subsequent leaders started trying to amend the 1960 constitution of DRC, beginning to think that Kinyarwanda speakers should now not be declared citizens of that country. Yet the constitution had recognized them as citizens. Now, when you look at that problem, together with the problem of the Interahamwes that had orchestrated a genocide against the Tutsi by 1994, that ran away and formed the infamous FDLR, that occasionally then substantive and subsequent governments in Congo started utilizing their military services as mercenary forces against any other establishments that would fight for rights. Now, that culminated into substantial insecurity against any Kinyarwanda speaker in Congo. Some of them that had run away from Rwanda after having caused havoc, they still met people that in their own measurements looked like those that should be the subject of the furtherance of their machetes. And they continued with the exercise, rapes and machetes and all that. So the younger people had to definitely pick up arms to protect their own parents and relatives. Now, those young people that actually came and formed the CNDP had got an agreement between them and the then government of Congo. I think that was the period of 2009, 2010.
Was Kabila?
That was Kabila. Yeah. So that agreement that was struck on March 23rd of 2009, that was an agreement that had the effect of resettling the questions and the issues that emanated and that actually befell the Kinyarwanda speakers of Congo. What happened? The agreement that it had to be accepted as a political organization, CNDP, yes. Demobilization and actual formation of a substantial government and giving security to their own people, yes. What happened? Government reneged on all agreements, that all the particulars of the agreement, started playing monkey tricks, chickenery and buncho, and mysteriously again started orchestrating havoc against the relatives of these people, using FDLR as a mercenary force against the populations, continuing with the killings and the murders, government managing, manning and directing the maiming of limbs of persons in Eastern Congo. This guy is discovered that was a violation of the March 23rd agreement and ultimately formed the M23. So, what actually now informed wrongly the government of Congo of the time was when the standard brigades were formed under UN resolutions and contributions from Tanzania, Angola, South Africa and all of that. And they thought that flashing out M23 meant flashing out the ideology of safety of their people. It will never happen. They had to regroup. Now it is a better force. Now it is no longer just the M23 because, as you know, they have even formed fronts with all the multiplicity of fighting forces, except a few, and I think now it is a governance question. So East Africa, if you are to respond to the cataclysm that is happening in Eastern Congo, you must use lenses of a possibility of secession or a possibility of power sharing that is permanent and believable in the Democratic Republic of Congo. Number two, the measurements must also be taken. They must take into account the possibility that there is a failure of government even to develop Eastern Congo and even to protect the people. So you must not only say that peace is the absence of war in Eastern Congo. No, peace is no longer the absence of war. It is the presence of security for the Kinyarwanda-speaking people and the people of Eastern Congo. It must be an answer to the development questions of Congo. Congolese are those people that see a lot of planes landing in forests and taking off with minerals, but without roads that can even take anybody to go nearer to such an aircraft. Government is being led by those that actually never stayed in Congo for a bigger part of their childhood. So they don't know what Congo is. If you have a president that can deploy a soldier only to be told that that soldier died 10 years ago, in my opinion, that is a level of failure that cannot be used as a raw material for the establishment of robust peace for the people of Eastern Congo. So East Africa, we warn you. This time handling this program, you must now look at the templates of South Sudan and Sudan. That is the best way to handle the Congo situation.
The emergence of foreign mercenaries,
yes,
somehow raises concerns that there is an external force in this conflict. What's your take on that?
Well, there is an external force that we know. The force of contributors to the brigades that have now failed. I know, for example, as somebody who has been following much of these issues, that the M23 have even the capacity of taking over the government of Congo. But that, of course, they are wary of the international nature of state formations and state governance. Therefore, what they have done so far has the object of protection of their own people. Even the former president himself has identified that actually it is because of the help of M23 that he had his own homestead secured. Otherwise, he would also be now one of those people listed as derelict, pursuant to government conduct and misconduct. What I think is something that we must now identify. The government of the Republic of Burundi, I do not know, because their participation, they are almost becoming protagonists. I have a feeling that the principle of hot pursuit might lead some countries to lose power, to obtain power change in certain countries. If you pursue M23 and you want to run that project as a substantive country, and this one I'm addressing the Republic of Burundi, I have a fear that once M23 obtain the capacity to pursue you and use the principle of hot pursuit, they can form a new government even in your own country. Why do you have to act that way? In my opinion, I think there needs to be a lot of sanity established when we are handling issues of Eastern Congo. Today, M23 needs to quickly establish centers of governance. We need to see how they can begin to look at taxation, to look at development, road connectivity, and they must now begin to redesign and allay the fears of the West, particularly because what we are looking at, Congo is just like, it is a very big problem because it has all the resources necessary to almost run the whole world without a government that can actually manage the resources. So independent economic centers have independent substantial agreements for the enjoyment of the resources without necessarily having the people enjoy the proceeds of such enjoyments. Now, the interests are a multiplicity. The interests it is very hard to obtain a consensus on matters to do with the Congo, even on the international world, because the interests are immense. Public relations stunts are flying all over. United Nations will arrive at resolutions that actually sound political, but when at the back, in terms of backstage politics is actually economics. Access to lithium, access to timber, access to gold, and a multiplicity of companies are now running Congo when the president is just, you see, they have all become the catechists. The president is just the high priest celebrating the mass, but he doesn't even administer the Holy Communion himself. So now that is the problem in Congo. There is no governance. And that has to be established better.
Thank you, Honorable Mbidde. Let's shift gears. Quickly, we come back home.
Yes.
Let's talk about legal and political tensions in East Africa. The ongoing trial of Colonel Dr. Kizza Besigye in Machindi has also raised some major concerns. And Dr. Mbidde, you are an exceptional lawyer. You are a distinguished lawyer. What does it mean to try a civilian in a military court? And what does that mean for Uganda's democracy?
It is a question of government goodwill. You see, justice, fairness, democracy, all of those can be written. But implementation is in terms of those that have the power to do so. The government of the Republic of Uganda needs to choose. I can say safely that when you look at the law, obviously the UPDF Act allows a court martial to try persons that are civilians that have been found on the west side of the law, where particular tools of their trade in criminality include guns. Now, that is a provision that has been substantially challenged in all courts of law, including the Constitutional Court has already given a decision against it. But even before such a decision is given, there is a constitution that somebody should now rely on to take decisions of where to try suspects of any criminal tendencies. It is impossible for you to tell me that it is democratic for any suspect not to be tried at all. But it is actually justiciable and democratic that suspects are tried in courts where justice can be actually administered. The constitutional provision of Article 210 of the Constitution of the Republic of Uganda gives Parliament powers to enact a law for the management, recruitment, and discipline of the Uganda People's Defense Forces. Now, that is the law that provided the Parliament with the powers to enact the Uganda People's Defense Forces Act. Now, that act provided for the court martial as a disciplinary organ, contemplated under Article 210 of the Constitution that I actually read for you. Now, I know that not all viewers are lawyers, but when Parliament is given powers to enact a law, they can only enact a law within the precincts of those powers. Now, the powers given to Parliament under that article were to enact a law only for members of the Uganda People's Defense Forces. So clearly, however criminal you are, the kind of crime you commit cannot be a procedure for recruitment into the UPDF. Accordingly, you cannot be disciplined as a member. So that one can be understood even before you go to court. Without even going to court, for a government that has the goodwill to offer justice and democracy, no civilian would have been taken to the Army General Court Martial, because it is clear. Number two, the substantive court procedures and processes recognize trials of persons that are engaged in treason. In my opinion, treason includes, amongst the tools used, guns are inclusive. If Dr. Kizza Besigye is seen by the wayside of treasonable activities, the High Court of Uganda applies with equal force. It has full powers to try his case. Number three, the nature of arrest of a crime committer, also has got very fundamental, important issues that we must raise that are legal issues in nature. Treason, or possession, unlawful possession of weapons, for example. If I am found in Kenya, then the laws of Kenya apply with equal force. Laws of Uganda have got jurisdiction. Courts of Uganda equally have jurisdiction. It is very unlikely that I can commit a crime against Uganda while in Kenya. It is very unlikely. Otherwise, then it is the Kenyan government that should be a complainant in the case, in the circumstances. Because our cases are Uganda versus so and so. That is the nature of criminal law. Why? Because criminal law is embedded in principles that are buttressed in again, substantive principles. Now, the principle of nulla crimen sine lege or nulla poena sine lege applies with equal force. That for you to be accused of committing a crime, that crime has got to be provided for in the laws of the country, and a sentence for anyone found guilty of such a crime equally has to be mentioned somewhere. It has to be, of course, provided for. Now, all of those are laws of giving provision on crimes committed in a substantive country. That law doesn't apply in Kenya. It cannot apply to you while in a different country. I think that is a sham trial. Sham trials, of course, have the effect of curtailing one's freedoms. The state is so big that probably it can still go away with it. Dr. Kizza Besigye will come out and definitely take government to court. And of course, he will spend all his lifetime trying to argue cases where government knows that it actually, by intention, is violating the rights of Dr. Kizza Besigye.
Yeah, so Honorable, where does this leave the cooperation and the rule of law in the region? If someone can be arrested where it's not necessary that he should be arrested from another country, like, for example, you have elaborated.
It is an unfair situation. It is, you see, Uganda is now faced with the pendulum movement in history, swinging from absolutism to democracy, and from democracy back to absolute dictatorship. Now, it is a pendulum swing, and whoever, instead of clinging on, you start gazing upwards, you will become this and fall off. So that is now the unfair bit that actually is happening in Uganda. We expect that this has to stop, because now we had actually started testing democracy, but now the swing is going back to absolutism with almost the same speed as on the way it had gone. So now that is a very major worry, and I expect the country, particularly the leadership of Uganda, to make sure we actually revert to the laid out course that is democratic in nature.
Honorable, thanks a lot for your time. Now, I have a few more questions. The Banyarwanda question. I'm very lucky that you're the legal advisor or the legal representative of this group of people. Despite President Museveni's recent executive order, many argue that the real change can only come through constitutional means.
That is true.
What legal obstacles still exist in this?
Yes, first of all, let me, you see, an executive order, and I think I would like to say this because there are people who had started suffering excitement that an executive order has anything to offer. Now, the laws of Uganda, particularly when you look at even decided cases, the case of Horizon Coaches and the case of Nakasero Markets, these are two authorities where the Constitutional Court and the Court of Appeal decided that unless anchored or buttressed in the law, an executive order does not have a force of law. That is the position of the law in Uganda. It is just like a campaign poster where somebody begins to tell you that I have come forward to be voted for purposes that we shall have development and prosperity for all. You cannot begin going home and jubilating that actually you have developed yourself. So, because that is just a campaign. Now, an executive order is just a campaign. It is administrative in nature, and administration now itself has to follow the law. So it leaves you in the same state as before such an order has been issued. So in Uganda, we are looking at, because when you call them Banyarwanda, then you miss the point. Let us call them Kinyarwanda speakers. We have got 5 clusters of these people. And all of these people think that they are called Banyarwanda in the 3rd schedule to the Constitution of the Republic of Uganda, and accordingly that they are citizens. And the unfair bit is that that is not correct. So what is the correct issue? The correct issue on the citizens of Uganda by birth is embedded under Article 10 of the Constitution. So the only Ugandans by birth are those people whose either parents or grandparents, either of the two, either your mother or your father, either your grandfather who is maternal or paternal, either of the two must have belonged or must have been a member of an indigenous ethnic community in Uganda as at 1st February 1926. So the threshold for determination of a citizen is on membership to an indigenous ethnic community in Uganda. And the cutoff, the point from which you begin measuring such indigeneity or indigenousness is 1st February 1926. So whoever lingers within the corridors of arrival, whether you arrived before 1926 or after, you just came. Now membership refers to membership, not arrival. Now this is something that people do not know. And that provision now kicked out a lot of people. So these are 5 clusters of Kinyarwanda speakers. The first cluster is those Kinyarwanda speakers with the descent from the borderline regions of Mpororo, Ntungamo, and Chisoro. They are Kinyarwanda speakers by virtue of historicity that their areas actually belonged to the former Rwanda Kingdom. Now, pursuant to the demarcation of the Uganda Protectorate, not the Republic of Uganda, and you see a lot of people make a lot of wrong analysis thinking that that was Uganda. That was the Uganda Protectorate. Uganda started in 1962, and that is 9th October. That is when sovereignty ensued, and that is when the first citizen of the Republic of Uganda was now identified. So, but that is now besides the point. That is more legalistic than what the public would understand. So, the boundary demarcation now put Kisoro, Mpororo, and Ntungamo as a part of Uganda Protectorate, which is now declared Uganda by 1962 Constitution. Those are Kinyarwanda speakers. Actually, those are the indigenous Banyarwanda. So those ones, the Constitution takes care of them. In fact, they are even at liberty to Christian themselves different ethnicities. Some of them call themselves Bafumbira, others Bahororo, others have even taken part of Bachiga. They are fine. Others even call themselves Banyankole. But that is the indigeneity that you can discover of a Kinyarwanda speaker. Who are the second ones? The second cluster of Kinyarwanda speakers are those that are the subject of intermarriage between a Munyarwanda, and it does not matter when that Munyarwanda came, and a person identified as a member of an indigenous ethnic community. For example, Muganda. For example, me, myself, my mother is a Muganda. So I am now part of the second cluster of the Banyarwanda, where the father came in the 50s, but found a mother who actually belongs to the indigenous ethnic community. So the Constitution recognizes me as a citizen of Uganda by birth as the second cluster, Munyarwanda. So you get that point. Those are two. The Mpororo group, the intermarriage group. Two safe clusters of Banyarwanda. Now there is a third cluster. Persons that actually were part of the labor force during colonial times. Those are those that came. They are not the subject of intermarriage, but their grandparents came in the 1930s and entered Uganda. Today, those are not recognized as citizens of Uganda by birth, including their offsprings, their children and grandchildren. They already thought they are Ugandans by birth because at the issuance of national IDs to Ugandans by birth, they even obtained the national IDs. I will get to that. Now that is the third cluster. The fourth cluster of Kinyarwanda speakers is the cluster of those that came during the 50s, 1958 up to around 1961, running away from the bad ethnic politics of the then makeshift that you can now call Uganda, I mean you can call the Republic of Rwanda now. You get the point. Now that is, in fact, internal affairs often refers to them as the 59ers. That is now a fourth cluster of Kinyarwanda speakers. Either of those that are running families that are not the subject of intermarriage with an indigenous ethnic community under the current constitution are also not citizens of Uganda by birth. Now the fourth cluster, they are those that ran away from Rwanda after the cataclysm of the genocide against the Tutsi in 1994. They are here and their children are also here. Now they are also Kinyarwanda speakers. When they look at the constitution, they think they are called the Banyarwanda. They are the Banyarwanda in the constitution.
The ones are being
now, those ones left the Republic of Rwanda when it was a country. Those are not supposed to be citizens of Uganda by birth, and indeed they are not. If anybody tells them to naturalize, as the executive order states, that means they have got a citizenship they can renounce and adopt a citizenship of Uganda by registration. The rest of the four clusters do not know any other country. They all left Rwanda before it became a country. You cannot tell them to go back to what is now a country.
And you cannot tell them to...
And they are not staying here because of the wrong law. So they are actually belonging to what we call stateless persons. Over 6 million people. Now those are the very reason that have made it a logical necessity for us to run a campaign that is intended to amend Article 10 of the Constitution. Why? Because we want to establish a criterion that we call jus soli. It is an international law principle on citizenship, that where you are born is where you are a citizen by birth. Today, the Constitution recognizes only jus sanguinis, that you can be born elsewhere, but once your grandparents or parents are citizens of this country by birth, you become a citizen. Now we want to also accompany it with, one, the establishment that when you are born in Uganda, you should be a Ugandan, and two, avoidance of ethnicity in terms of determination of citizenship. Because it is no longer fashionable, really. We are in a constitution, a situation of constitutional autochthony. Now, we are autochthonous enough in order for us to determine what we want. Ethnicity is not the subject of municipal law, yet citizenship is the subject of municipal law. Ethnicity is the subject of international law because ethnicity is extraterritorial. It doesn't belong to one territory. So you cannot use it as evidence to determine a citizen by birth. It is extraterritorial, it is as amorphous as it looks, it is definitely something you cannot refer to. Number three, citizenship is personal. It must not be evidenced by way of other people, whether parents, grandparents, or ethnic community. For me, it is outright balderdash that anybody requires you to prove personal citizenship by birth, where evidence required is for a whole community, and that the community is ethnic, and that it can be some parents or some grandparents. What is happening to people from such babies' home that we are actually dropped there and no parents can be traced? I think those are supposed to be citizens of a country by birth pursuant to the exhibition of a birth certificate. So I think Uganda needs to actually adopt proper frameworks of jus soli, that where you are born is where you are a citizen of a country. The final thing is I have heard Nico Pomps, Wazoks and Palokas here saying that if you guys want to enjoy the peace here, you should stop christening yourselves as Banyarwanda. Because the moment you say you are Banyarwanda, then you begin to sound like you are members or citizens of Rwanda. Now, those are people that are actually suffering and whose reasoning is tainted with myopia. When you go to South Africa, we have got persons called the Soto. They are called the Soto of South Africa, but there is a country called Lesotho, and there is no problem with it. There are people called the Swana, but there is also a country called the Botswana in South Africa. We have got the Somali in Kenya, but there is also the Republic of Somalia, and there is no problem with it. For you to tell me that when you change your name, then you have changed your character, in my opinion, I think that is myopia. Even a rat is aware that it doesn't matter how many times you change the name of a cat, it cannot associate with it. Because what eats it is not the name of the cat, it is the character. So I think those are things that we need to solve. And I think that is why we are running a serious campaign to make sure citizens of Uganda are recognized as citizens.
Wow, Honorable, I wanted to ask you one final question, but maybe you have answered it already. But
yes.
Maybe moving forward, how do you think Uganda can a lasting legal framework to ensure that the community is left?
Yes, the framework is definitely the amendment of that article to include the jus soli, jus sanguinis. You're a citizen because you are born, you're a citizen by birth. Those that are not born here but came from other countries when they were countries. You see, in Uganda, the first citizen of a protectorate that is actually registrable and recognized under the law is that kind of a citizen that became a citizen under the British Protected Persons Order of 1934. Now, that order gave rise to a schedule, and that schedule includes the countries where all of those that were found in those countries were declared citizens by 1934. That schedule includes Uganda as number 12 in the list, I think next to around Nigeria. And so that means that Ugandans have been citizens of Uganda by birth, recognized since 1934. Banyarwanda, those that just came in 1930, by 1934, they became fully-fledged citizens. So for you, don't believe in the boundaries drawn by Europeans only. No. Also believe in the laws generated by those Europeans. Because, I mean, you cannot be selective. For us in law, we call it the doctrine of election. The doctrine of election presupposes that whoever accepts a benefit cannot do away with the burden that accompanies it. So once you jubilate over a benefit of having boundaries drawn by these people, the accompanying burden of recognition of the same people who are inside the boundaries should also be partaken. And that is the very basis for which we believe that the 1995 Constitution, exclusion of Banyarwanda as citizens simply because they came after 1926 was in error. Because the 1966 Constitution that created Uganda under Article 9 recognized them. The 1966 and 67 Constitutions never amended that position. It is only the 1995 Constitution that actually amended the whole. They didn't have even a right to amend citizenship by birth, which they did, and for that, we are pushing government to make sure the amendment is done to the extent that if it doesn't, then we will reach out to courts of law, particularly the East African Court of Justice, to make sure they can advise partner states on what to do.
Honorable, thank you so much. I'm
Welcome.
so glad that you're even an expert in the, you said, East African Court of Justice.
Yes.
You have been there a lot. So
yes.
I am sure the journey you're taking will
Yes, and it is funny. We would have gone to the African Court on Human and People's Rights. But you see, there is a requirement under the protocol that forms that court, under Article 34, Clause 6, that for Ugandans to sue in that court, then Uganda ought to have deposited the declaration accepting the competence of the court, which they have not done. So we can't access, but we will go to the East African Court under Article 60D and 72 to find a ground of advising the country on which steps to take.
Honorable, thanks again. I am
welcome.
Profoundly honored and exceedingly humbled to
Thank you.
Had an opportunity to host you.
I think I have been very clear now.
Very clear. And I'm sure my audience now knows one or two about this.
Thank you, my brother.
Yeah. My viewer out there, the perspective crosses borders. It's not only in Kigali. We are here to keep giving you the best stories, the best programs, all that you need to know, what builds you, what you need to avoid, and what you should take seriously. From me, until then, it's goodbye.